Well, good morning, everybody. Hi there, Dark Side. Glad you could join live. There was a tweet last week that I'll get to in a few moments, later on, by Steve Drizzen. That I found the article very interesting, and it made me think of the plea deal. Although the article is not about the plea deal, it's more about a judge who obviously went to the same terrible school of judges as Angela Superwitch, and in his own way is doing his best, as Angela has done, to try and prevent justice. Anyway, we'll get onto that later. The plea deal, for me, it's a huge problem. So I've got several articles, 5 lined up for us to have a look at. They're not very long, so we'll have a look at the first one here. Hi there, Sharon. So here is article number 1. Let me just check, make sure that everything is going as it should. So here we have this first article from John P. Guidry II, Orlando Criminal Defense Attorney log. Put that back up a wee bit. So we get the title. Some jurisdictions have banned plea bargains. So this is November 28th, 2011. I've done a bit of research. In another article, it says that in 1990, only 19 countries in the world had the plea bargain. Unfortunately, as of 2017, that number has increased to 66. What can you get me on this case? That's a pretty common question asked by criminal defense attorneys here in Orange County and most other places as well. But believe it or not, it's not always legal to obtain a plea bargain. For sure, some judges ban plea deals after a case has gone past a certain point, noting that there will be no plea agreements after docket sounding. All pleas at that point a wee bit too far. Some judges ban plea deals after a case has gone past a certain point, noting that there will be no plea agreements after docket sounding. All pleas at that point are blind to the bench, meaning essentially that the judge wants defendant to plea within a certain time frame, or all bets are off. Other jurisdictions have taken plea bargain bans a step further. In parts of Alaska, New Orleans, California, Ventura County, and Michigan, Oakland County, plea bargaining has been terminated, gone illegal. So, what is the result? In Subverting Justice, writer Robert Bidinotto argues that ending plea bargains puts the responsibility back into every level of our system. Police do better investigating. Prosecutors and lawyers began preparing their cases better. Lazy judges were compelled to spend more time in court and control their calendars more efficiently. Most importantly, justice was served, and criminals began to realize that they could not continue their arrogant manipulation of a paper tiger court system. However, I don't agree with this position on almost every level, but you know what they say about opinions. That being said, many countries have outlawed plea bargains. Even though plea bargains are sometimes a good thing, there are tons of problems with plea bargains. Most troubling for we criminal defense attorneys are the innocent citizens that accept deals due to fear. It's heartbreaking. This problem is most common in cases where a client is totally innocent, yet the charges are so severe that the defendant pleads to a lesser offence so as not to risk life in prison. And if you really want to see injustice spiral out of control, just look at any co-defendant case where a few innocent citizens are arrested with a few guilty ones. The guilty ones are perfectly willing to testify against the innocent if that testimony will give them a favourable plea bargain. Fair? Hell no. Reality? Yes. Plea bargains are very common in the criminal justice system, as most citizens cannot afford to risk their freedom on a jury of 6 strangers from the community, as nice and friendly as they may be at times. Plea bargains are promoted in the criminal justice system because without them, the system would grind to a halt. There is absolutely not enough time or resources to pick a jury for every single lawsuit brought by the state of Florida against its citizens. Should we ban them, as some jurisdictions have done? No. With a good criminal defense attorney, a citizen can make a well-informed decision. A few prayers never hurts either. We often hear about this, don't we? That, plea bargains are promoted in the criminal justice system because without them, the system would grind to a halt. I remember chatting with, I think it was myself, the dude, I think Mark Hodinett and Rob Bellin. And he also pointed out that, this was a big problem, the amount of time that it takes to, it's so easy to clog up the system. Which, as I say, was part of the reasons why this, the last article that we'll look at from tweeted by Steve Drizzen is so interesting. Okay, let's have a look at the next article, the benefits of the plea bargain. So this is from Nolo, the benefits of the plea bargain. A lesser charge, lighter sentence, and getting everything over with quickly are some of the benefits of negotiating a plea, by Paul Bergman, UCLA Law School professor. For most defendants, the principal benefits to plea bargaining is receiving a lighter sentence for a less severe charge than might result from a conviction at trial. Example, don't know why it has to be Commander O. Empire, is charged with 20 counts of burglary after a spree of burglaries in his neighborhood. Assistant District Attorney Art Mills offers to drop the charges to 2 counts of burglary if Pyer pleads guilty right away. Pyer takes the deal because his sentence will be shorter and he will be eligible for parole earlier than if he were convicted on every charge at trial. Another fairly obvious benefit that defendants can reap from plea bargaining is that they can save a bundle on attorneys' fees, assuming they are represented by private counsel. It almost always takes a lot more time and effort to try a case than to negotiate and handle a plea bargain, so defense counsel typically charge a much higher fee if the case goes to trial. There may also be other benefits for defendants who plead guilty or no contest, such as the following. Getting out of jail. In custody defendants who either do not have the right to bail or cannot afford bail may get out of jail immediately following the judge's acceptance of a plea. Depending on the offence, the defendant may get out altogether or on probation, with or without some community service obligations. Or the defendant may have to serve more time, but will still get out much sooner than if the case had gone to trial. Benefits of moving from jail to prison. Even if the plea results in the defendant being moved from jail to prison, even this may occasionally be a benefit. A move to prison can be a step up if the jail conditions are worse than prison conditions, and convicts in prison may have privileges that defendants awaiting trial in jail don't have. Furthermore, even when defendants go to prison, there is some intangible benefit to simply having resolution, knowing how long they will be in, rather than spending what may seem like endless hours waiting around in jail. Getting the matter over quickly. This has the intangible benefit, touched on above, of providing resolution to what is almost always a stressful event, being charged with a crime. People who are charged with a crime while on vacation, for example, might opt for a plea bargain in order to get back home sooner, and defendants with jobs who are charged with minor offences may prefer to resolve the case in one court appearance rather than missing work repeatedly. Going to trial usually requires much more time in court than a plea bargain. Having fewer and or less serious offences on one's record, pleading guilty or a no contest in exchange for a reduction in the number of charges or the seriousness of the offences looks a lot better on a defendant's record than the convictions that might result following trial. This can be particularly important if the defendant is convicted in the future. For example, a second driving under the influence conviction may carry mandatory jail time. But if the first offence has been bargained down to reckless driving, for example, there may be no jail time for the second arrest. Even for people who are never rearrested, getting a charge reduced from a felony to a misdemeanor, or from a felony that constitutes a strike under the three strikes law to one that doesn't, can be a critical benefit. Some professional licenses must be forfeited upon conviction of a felony. Future employers may not want to hire someone previously convicted of a felony. Felony convictions may be used in certain court proceedings, even civil cases, to discredit people who testify as witnesses. Felons can't own or possess firearms, and in many jurisdictions cannot vote. Having a less socially stigmatizing offence on one's record. Prosecutors may reduce charges that are perceived as socially offensive to less offensive charges in exchange for a guilty plea. For example, a prosecutor may reduce a molestation or rape case to an assault. Conviction of the lesser charge in this instance may allow the defendant to avoid having to register as a sex offender for the rest of his life. Also, a lesser offence may lessen the likelihood that family members and friends will stigmatise a defendant. Of more immediate concern, sometimes defendants convicted of stigmatising offences are at greater risk of being harmed or killed in prison. Avoiding hassles. Some people plead guilty, especially to minor first offences, without hiring a lawyer. If they waited to go to trial, they would have to find and hire a lawyer, spend at least some time working with the lawyer to prepare for trial, and pay the lawyer. avoiding publicity, famous people, ordinary people who depend on their reputation in the community to earn a living, and people who don't want to bring further embarrassment to their families or may choose to plead guilty or no contest to get and keep their names out of the paper as quickly as possible. While news of the plea itself may be public, the news is short-lived compared to the news of a trial, and rarely is a defendant's background explored in the course of a plea bargain to the extent it may be done in trial. Keeping others out of the case, some defendants plead guilty. Dear. Let's see if I can get I think I've got it, yeah. Some defendants plead guilty to take the blame, sometimes called the rap, for someone else, or to end the case quickly so that others who may be jointly responsible are not investigated. And finally, avoiding deportation. Non-citizens who plead guilty may be deported after they have finished serving their misdemeanor or felony sentences. Defense lawyers must inform non-citizens that deportation is a potential consequence of a guilty plea. For non-citizens charged with crimes, therefore, pleading guilty to an offence that reduces the likelihood of deportation is another potential benefit of plea bargaining. Okay. I think this was one of my favourite articles, though. 15 serious advantages and disadvantages of plea bargaining. Plea bargaining is an agreement used in criminal cases to avoid a lengthy trial. Here, the prosecutor and the defendant work together to agree with each other instead of taking the litigation to a jury. It often includes things like pleading to a lesser charge and pleading guilty in exchange for a lighter sentence. It is highly common in the US, where many cases are settled through plea bargains than by trial. I presume it means where many more cases are settled through plea bargains than by trials. This type of legal agreement enables both parties to avoid a prolonged trial under court and enables the defendant to avoid the risk of a guilty verdict at court, which can lead to a more severe sentence. Plea bargaining has been carried out as an intentional agreement that leaves the defendant and the prosecutor better off, in which the former have various procedural and substantive rights. However, if the defendant pleads accountable, he is trading his rights to a prosecutor in return for concessions that are highly respected than surrendered rights. With all, plea bargaining has become a hot topic in debates whether it is good for the society or not. To get a good idea on the subject, let us take a look at its advantages and disadvantages. Advantage number one. Yeah, I would say so. It helps deal with caseloads. In plea bargaining, the state and the court are aided in dealing with caseloads. Also, the process decreases the prosecutor's workload by letting them prepare for more serious cases by leaving effortless and petty charges in order to settle through. It makes trial scheduling uncongested. For the judge, the key benefit of accepting a plea bargain agreement is that he can alleviate the need to schedule and hold the trial on a docket that is already overcrowded. Judges are also aware of overcrowding in jails, so they might be receptive to process out offenders who are unlikely to do much jail time anyway. This means cases will be closed much quicker, which is good for the society as the method declogs court systems for more serious cases. It hastens the process of trials. Plea bargains are a significant factor in restructuring offenders by letting them agree to the blame for their trial and by letting them voluntarily submit before the law without having expensive and time-consuming trials. It eliminates a case's uncertainty. From the criminal defensive perspective, the most useful benefit of this type of agreement is its ability to remove the uncertainty of a trial. It helps defendants with making sure they will not receive more serious charges for their criminal acts filed against them. It brings a great possibility to find the accused guilty. When it does happen that the prosecutor is feeble or that the court wants proper witnesses or evidence and the outcome is likely acquittal, it is possible that the prosecuting party will still find the accused guilty. It prevents a case from getting worse. When a charged individual takes a plea bargain, he will not have to go through trial. This means that some crimes which may have been committed and any damning evidence are not going to be discovered. It does not allow maximum sentence. One of the biggest reasons why many people opt for plea bargaining is the fact that they cannot receive maximum sentences for their crimes. It may allow for aiding larger cases. In a plea bargaining agreement, prosecutors will often roll other conditions for the defendants to testify against a co-defendant, which might help solve larger cases in a prosecution. It lets the justice system breathe. If all criminal cases should make it to trial by jury, then our now I'm not saying that word, legal system would not be able to sustain themselves. Courts will probably be backed up by months or even years. This is so sensitive, so I'll try and get it just there. We go. The list of disadvantages of plea bargaining. I think we're pretty much agreed that plea bargaining is a terrible thing. It allows presentation of the accused with unconscionable pressure. In a plea bargaining agreement, the prosecution can present the accused with unconscionable pressure, and even though the process is controlled, there is still a chance of it being coerced. I know. How about number two? How about number two? It can lead to poor case preparation and investigations. Some judges and attorneys argue that plea bargaining has led to attorneys not taking the time to properly prepare their cases and poor police investigations. They believe that rather than pursuing justice, the parties would rely on making a deal where the details of what happened and their legal consequences will become less important. It may be biased to the prosecution party. Plea bargaining might allow prosecutors to take full advantage of accepting criminal acts in the weakest trials. The more beneficial will be a guilty claim for the prosecution is if the trial ends in acquittal. It might charge innocent people guilty. Even if you are innocent but agreed to a guilty plea, you still have to pay a fine or be imprisoned for a crime you did not commit. Not only this, but you will also have a criminal record that cannot be erased. It is unconstitutional. It is argued that plea bargaining is unconstitutional as it takes away the defense's constitutional right to a trial by jury. If the defendant is pressured or coerced into such an agreement, then this argument may have a considerable weight. But if the defendant at all times in the criminal case retains his right to a trial by jury without pressure to make an agreement, then the court finds that this procedure remains constitutional. It can make the system suffer, since both the defense and prosecution parties depend on their power to negotiate a deal instead of ruining a trial. The justice system, said it by mistake, the system might suffer. If both parties agree on a plea bargain, then the agreement shall be stated clearly on the court record before a judge who will issue the sentence that is agreed upon. Plea bargaining can have benefits for defendants and for society, whose interests are represented by the government prosecutor. However, it is always important that both the prosecution and defending parties carefully weigh their options before reaching an agreement through a plea bargain. Well, I'd have to say that it's very disturbing, but if you haven't done so already, really, you want to watch Kalief Browder, the Kalief Browder story on Netflix. It's called Time, the Kalief Browder story. It is harrowing. It has both a very tragic ending and a little ray of hope, a little ray of sunshine at the end. But very much, I would strongly recommend Kalief Browder's story. We hear that one judge is brought in to try and persuade 70 people that appear in front of her one day to take the plea deal, and to basically have time that they've already spent in prison be time served so that they can walk free. But of course, with their record of having been found guilty. It's quite disturbing, isn't it? It reminds me of this simple fact, that anybody that hires Kathleen Zellner would be a fool to hire them if they are guilty, because she will find out that they are guilty. For me, it would be totally foolish of anyone not to take a plea deal if they're guilty. But anyone who refuses to take a plea deal, clearly that person is innocent. To not, to not give in to that pressure. I must admit, I got in touch with Tracy Keogh, of course, Tracy of the Justice and Freedom for Brendan Dassey site. Everybody knows Tracy, and of course, recently she's done an excellent series of podcasts called, of course, The Sixth Hour. And I got in touch with Tracy and I said, well, Brendan, what was the actual state of affairs with his plea deal? Was it a case of it was withdrawn? Was it rejected by Brendan? So anyway, she very kindly directed me to this particular email. So let's have a look. I think it's this one here. Yes, here we go. So this is Mark Fremgen writing to Ken Kratz, along with Ray Edelstein. Thanks for your email. I will discuss this matter with Edelstein. Sincerely, Fremgen. And then here is the original message, the original sweaty message. Just wish I could control this bar a bit better at the side here. and get it to move where I want it to. Okay, November. Let's try this one. November 30th, 2006. Mark, other than the subpoena for Attorney Kaczynski, I have not received any further information from you regarding the December 15th motions. Are you going to be filing any other motions? When the court directed you to provide legal authority for seeking a pre-trial remedy for your claim of ineffective assistance of counsel, I assume since you cannot prove the prejudice prong of that claim until after the trial is concluded, did you plan to respond? I noted that you have hired an expert in the area of false confessions. Presumably, that's his field of expertise in this case. Have you provided your expert with all the statements by your client? As an example, the phone calls from your client to his mother admitting his involvement in these crimes. I'm guessing your expert will need all those admissions to render a reasoned opinion as to whether the statement by your client is false or not. Attorney Kaczynski, when he advanced this same false confession theory, sent to the court a learned treatise on false confessions. He conceded that the document did not support his position that this series of statements of his client fit into that category. And in fact, the author of that very article concludes the same thing, recognizing the likely outcome of that theory of defense. Attorney Kaczynski attempted to negotiate a reasonable resolution of this case for his 16-year-old client, attempting to secure his release from prison sometime before his life expectancy ended. As you may be aware, we are literally a day or two away from completing the plea agreement before Brendan's mother, with the prompting of Stephen Avery, engineered Mr. Kaczynski's removal from the case. Still moving. Finally, it doesn't take a. I say this is really, really annoying. This way this thing works. It doesn't take a brain surgeon to recognise that Brendan's plea would be bad news for Stephen Avery and his frantic efforts to thwart the deal through the only avenue available at the time, removal of the attorney making the deal, succeeded in assisting Avery's defence. The problem, of course, was it was at the detriment of his nephew, who stands to be thrown under the bus by Avery at the trial, starting February the 5th, as the real and sole killer in this case. By the way, does your client understand that? Excuse me. Excuse me. Does he realize that Uncle Steve plans to blame him for killing, raping, and torturing Teresa? As you may suspect, my personal and professional opinion of how this situation has unfolded is unsettling. I know how Kaczynski got publicly outed by the boys in Madison. The boys in Madison, Dean and Jerry, and I know what good friend of Nick C were pulling those strings. What I continue to hope, however, is that Brendan has someone looking out for his interests. I thought Kaczynski was doing that, allowing him to be sacrificed by Avery and his team in February, with the natural conclusion that Brendan is saddled with life imprisonment doesn't seem just. That may, however, be exactly what happens. So, with that blunt history being provided, what are your plans in this case with Das's admissions, no matter how you paint the March confession, including his May statement to police, admissible as rebuttal if you ever claim false confession at trial? Admissions to his mom, not involving police at all, so no chance of being deemed involuntary. The physical evidence he directed police to, known only by someone participating in the murder, and that's completely false, Ken, as well. Are you really planning to go to trial? If not, now is the time to settle this case while your client still has a bargaining chip or two. How is this a game of poker? I don't know. If you wait until after his motion hearing, where he will surely disavow himself of his admissions, his utility to the state goes way down. Hence, my willingness to cut him any deal goes way down. Hence, he dies in prison. Even Barbiander should understand that mathematics. So, if you want to consider the same offer that was provided in May, convince your client that it's not in his interest to allow Uncle Steve to throw him under the bus at his trial. Explain to your client that no matter what evidence is advanced on the theory of false confessions, that all of his subsequent statements become admissible. Then contact me regarding the details of the agreement. If you believe that your client is better served by taking his chances at the motion hearing and resulting jury trial in April, kindly let me know that too. That's pretty shocking, isn't it? The pressure that Ken is putting the Mark Fremgen and Ray Edelstein under. I must admit, I hadn't seen that that letter before. So thank you to Tracy for directing me to that. And she's also sent me some other part of the case file to have a read of, but it's 200 odd pages, so it'll take me a little bit. Yes, Jazz. Well, he didn't, you arrogant. Yes. Okay. I think we've gone through everything I wanted to do. I think that's all 4 of those. Yes. We've done the some jurisdictions have the banned plea deals. We've just read through that letter from Kratz, the benefits of the plea bargain and the 15 serious advantages and disadvantages. As I say, for me, it's a nonsense, the plea bargain. I'm sure that Jerry told me that that's one of the things that, oh no, it was in the Dutch legal. I'm pretty sure the Dutch legal system does not allow plea bargaining. But of course, what was particularly interesting about the Dutch system is that there's no jury. It is just judges that they sit in front of. Anyway, here's the article by, here's the tweet of it. Here's the article that was in the tweet that was tweeted by Steve Drizzen that made me think about the fact that some people think that the plea bargain is a good deal, is a good idea because it unblocks the system. I don't think Khalif Browder thought that for one moment. But As I say, we've heard it many a time that it helps to free up the system, to help keep the system moving. And of course, in Brendan's case, quite shocking, the pressure brought to bear that Kratz tried to bring on those in that email. So finally, Syracuse man ordered to get psych exam in stabbing death he didn't commit. Syracuse. A Syracuse man appears on his way to having homicide charges dismissed after an investigation revealed that he falsely confessed to stabbing a man to death, his lawyer said. But a judge on Monday ordered that Robert Adams Jr. undergo a mandatory psychological evaluation first. So Adams, who was released from jail by prosecutors, will be required to undergo testing to see if he's competent to understand what's going on in court and to help in his defense. I do apologize, it's really slow and painful trying to get the pages up. The wrinkle here, of course, is that both sides expect that charges against Adams will be dismissed entirely. He wasn't the man to kill another person. That means Adams is going to undergo a court-ordered psychological evaluation for a crime that no one believes he committed. Adams's bizarre journey from accused killer to wrongfully accused to questionably insane began after he was at the scene of a May 6, 2019 attack that left Charles Jones dead. An intoxicated Adams was quickly identified at the scene as a suspect, and after an hours-long interrogation, he confessed. But an eyewitness who did not know Adams later told authorities that they had the wrong man. Prosecutors ordered Adams released from jail in January, 8 months after he had been detained. Adams' lawyer, Ken Moynihan, later called it one of the clearest cut examples of a false confession in recent history. Had Adams been convicted, he would have spent up to 25 years in prison for a crime he didn't commit, his lawyer said. In retrospect, there were numerous problems with the prosecution against Adams, all of which had been dismissed by the fact that he was on record confessing, Moynihan added. After noticing these problems, Moynihan contacted the district attorney's office, and for the first time, the eyewitness was shown clear video of Adams from police body-worn cameras. She told authorities that they'd arrested the wrong man. So what was the major discrepancy? The eyewitness had clearly told 911 that night that the attacker had fled, but Adams was still near the victim when police arrived. Also, the victim was killed with some sort of blunt object with sharp points, maybe a board with nails, but there was no such weapon at the scene. Adams did not leave the scene and had no way to dispose of such a weapon, Moynihan said. After the eyewitness's account, it appeared inevitable that Adams would have his charges dropped completely. But at his last court appearance before the pandemic, he became agitated in court and gave security a hard time. Not surprised, being wrongly convicted and coerced confession. Judge Matthew Doran ordered that Adams undergo a psychological evaluation based on his behavior in court that day. Then the pandemic hit and courts closed. Psychological evaluations were nearly impossible, and Adams, who has a history of homelessness, drifted out of touch. No one was quite sure if he'd show up at court Monday. His lawyer, Moynihan, no longer had a working cell phone for him, but Adams did show up Monday with no problems. And Moynihan told the court that both sides were close to working out the case. Coolican, whoever that is, and we've not been told who Coolican is, was not available, but another assistant prosecutor said that no agreement to drop charges had been finalized. Prosecutors are still hoping Adams might help them identify the true perpetrator, lawyers said. Until Monday, the judge hadn't realized that the plan was to dismiss the case, but Doran stood firm that Adams still needed a psychological exam after his earlier court antics. So Adams remains free, and the plan is still to drop the charges, but he'll need to get evaluated first. Typically, if someone is considered incompetent, then that person is institutionalized with medication and counseling until in a better state of mind. But Moynihan said after court that he doesn't think Adams would have to be taken back into custody, even if mentally unstable, for a crime that he didn't commit. You know, so for me, it just beggars belief that you've got somebody who's clearly innocent, and yet the judge still wants to abuse their power and authority in very much the same way that Angela Flowers, Super Witch, has been doing in Stephen's case. And this notion that, you know, that you have to take plea deals because it saves court time. What on earth is that judge doing? Wasting time, ordering these psychological evaluations on a guy who's been, you know, found guilty originally. Obviously, some sort of confession coerced out of him. You know, it's just bizarre, just bizarre. Anyway, I think I've kept you long enough today. I will catch you all again soon. Let's just run through who we've all got here in the chat. I think I've said hello to Dark Side of the Moon, to Sharon, Jaznaz. I don't recall. Yeah, not my verbiage. Dark Side. I don't recall. Dark Side of the Moon. Jaznaz again. Drama must remain on the stage. Yes. Oh, and did I see there Dr. Silkman just popping in to say hello? Did I see that? Ah, yes. Dr. Silkman, yes, hi there. Fingers crossed for your football team, but not for your cricket team tomorrow. Anyway, we'll catch you all again soon. Hope you found those articles interesting. For me, that email from Kratz to Fremgen and Edelstein. Let me just tell you what our exchange, mine and Tracy's exchange, was on Facebook Messenger. she sent this message. Hi, Paul. This email between Kratz and Fremgen confirms that a deal was indeed on the table for Brendan during the Kaczynski era and again with Fremgen. Hope it speaks to what you need. If not, let me know. And then she's put, have to say, this one always made me want to slap Kratz stupid. To which I replied, many thanks, Tracy. Any time, Paul. But that regarding KK, join the queue. She's put, you can have first dibs. I'll take Kaczynski. I'm sure the deal Kratz offered was 15 years. I have not seen any documentation of that proposed deal. This might interest you too, that Kaczynski had worked with Kratz before, and Kratz and he had entered into plea deals for their clients. Sorry, Paul, in wanting to give you as much info as possible. Check out Drizing and Kratz post-conviction from page 22 to past 42. I'm going to have a read of that, and then we'll pop that up maybe tomorrow. Okay, we'll see you all later. Thanks for joining in. Bye for now.